you know, I want to make this as interactive as possible. So please feel free to ask questions while I'm talking. I want to maybe do this a little bit differently because I know you have a lot of speakers today. So I want to think of this as sort of a consultation. Let's sort of pretend that, you know, we're sitting in my conference room and you're my potential client for the next 45 minutes, and we're going to walk through this. I thought about doing it this way because this morning, a good friend of mine, Jenny Peterson, hi Jenny, who's sitting at Wells Fargo right now watching this, says, Nick, I'm watching this, this better be good. So let's make it good. So we're sitting in the conference room, and what I typically start with is kind of tell people about my practice and kind of my perspective on this. And I do white-collar criminal defense and internal investigations pretty much 100% of the time. There's only so much of that work in Iowa. So I spend probably 50 to 75% of my time outside of the state of Iowa doing this work, which is great because it gives me a chance to see how other jurisdictions do it and how other offices do it. And I try to bring that to my practice here in Iowa. And so one of the first things that we talk about is, well, why are you sitting in my conference? What brings you here? And try to use this here. Is there a clicker?
Yeah, there's a wireless route.
Right. There we go.
There you go.
Okay. So, first, why are you sitting in my conference? Well, there's several reasons that may cause you to think, hey, maybe I need to conduct an internal investigation or advise my client to conduct an internal investigation. The first and most obvious is if you've received notice of a government investigation is already underway. So I get a lot of calls when companies receive a government subpoena. That could be a grand jury subpoena, which clearly signals it's going to be a criminal investigation, or it can be an administrative subpoena. And the trick there is a lot of times companies get an administrative subpoena as opposed to a grand jury subpoena, and they say, Nick, I'm in luck. It's not criminal. And I say, not so fast. You don't know that yet. The only limitation is if you're using a grand jury subpoena, they can't use that for civil purposes. But if they use an administrative subpoena, all bets are off. You can use that for criminal or civil purposes. Far less likely is if a company's been the subject of a search warrant. And we all know what that is. Or there could be some sort of regulatory inquiry, right? Your regulatory could have given you some kind of notice that there's an issue. There may also be a civil lawsuit, some kind of media report, an employee complaint, a whistleblower complaint. And again, this could be civil or criminal, right? Because as our Attorney General said, you know, they look at the False Claims Act, they look at the Iowa Consumer Fraud Act, and those penalties can be very stiff. False Claims Act, you're looking at treble damages plus fines. And in fact, a lot of times what I have is, and I have two of these cases right now, both outside of the state of Iowa, where there's an investigation. There's an investigation. And the DOJ attorney says, I don't know if this is going to be criminal or civil. We're still thinking about that. And because the methods they've used so far, those options are both still open to them. And so it could be a civil False Claims Act resolution, or it could be a criminal resolution. They're still thinking about it. So the next thing is, okay, well, look, I understand that I may have a problem here, but why do I have to conduct an internal investigation? Why can't I just wait and see if I get served with a lawsuit? Why waste the money now to do this? Well, you know, there's some obvious reasons. You want to stop and prevent future wrongdoing. You want to limit your legal exposure, right? Limit the potential damages that may occur. And you want to get ahead of the problem. Another big reason that companies are conducting internal investigations is cooperation. I know that a lot of you have heard the term Gates memo before. And that's kind of the new regime we're living under. Sally Yates is a friend of mine, actually. I served with her when I was the U.S. Attorney for the Southern District of Iowa. She was the U.S. Attorney in Atlanta. And then she became a Deputy Attorney General. I was still U.S. Attorney. And I was actually at the meeting at the Department of Justice in D.C. when she pushed out the Yates memo to the department and then met with her office afterwards. And I thought, wow, Sally, you know, if nothing else, this is going to give me a lot to talk about when I go back to private practice. Thank you. And so the big takeaways of the Yates memo that are causing more internal investigations is this. How it used to work is when a company had a problem, they would walk into the Department of Justice and they'd say, okay, look, I understand there's a problem here. We want to go ahead and resolve this, plead guilty, whatever you want to call it, maybe enter it into a deferred prosecution or a non-prosecution agreement. We're going to agree to pay a fine, because that's what companies do, right? You can't put a company in prison. They pay a fine. We're going to pay a fine, and then we'd like to go about our business. And we would, as part of the agreement, you're going to agree not to go after the officers and the employees in our company. And that was fine. That was fine in a lot of circumstances. Now they're saying, no, that's not okay. First, that's not what cooperation is. That's what acceptance of responsibility is. Cooperation, when the Department of Justice says cooperation, what they typically mean is cooperating against somebody else, right? Causing a case to be made against somebody else. And that's why we want you to include all facts you know about individuals who may have committed wrongdoing in your company. Only way to do that is an internal investigation. They also say, look, cooperation is all or nothing. It's not an a la carte situation. You can't come in and say, look, we're going to tell you most of what we did, but there's certain things that, you know, we want to talk about, including maybe individual actors and what they've done. They're going to say, no, you don't get credit for any of that. And what you don't want to do is to spend all this money and go 90% of the way and then not get any benefit out of it. In fact, maybe harm yourself. The other reason that this is causing companies to do more internal investigations is, as I mentioned, kind of the different definition of cooperation. Now, really what the Department of Justice is expecting of you is kind of what they call proactive cooperation, right? In other words, I've had other lawyers call me and say, hey, look, I'm cooperating with the government, but I may need you to get involved. I said, okay, well, what are you doing so far? And they say, well, I've responded to the subpoena, and, you know, they called me a couple of times, and I've answered their questions, but, you know, we've responded to the subpoena, and I think we're cooperating well. And they said, no, you're not. You're doing that which you're legally obligated to do, but you're not really cooperating. You're not fighting them, but you're not really what they would call cooperating anymore. What they really mean by cooperating and getting credit for that cooperation, right, getting a discount on that fine, is they want you, and I do this all over the country, to say, okay, look, if let's say you've done this, and I've done this recently, you have a grand jury subpoena or some other kind of subpoena out there, you've produced the documents, and then as you produce the documents, you say, okay, look, before you've had a chance to review and digest those documents, we want to come out and do a presentation for you, okay? Because we've looked at it. We've done an internal investigation. We know what happened. And then you go out there and you sit out there for 6 hours. I've done this with the Department of Justice, with the SEC, all over, and you walk through binders of the documents and you explain to them what happened. Now here's the trick. You're not waiving the privilege. I don't recommend that you typically waive the privilege. Some people do. And you walk them through the documents they already have, right? So you're not waiving any kind of privilege. You're not giving them anything they wouldn't otherwise eventually get, right? And they are going to get it eventually, trust me. But you're helping them out getting it early. And you're showing them that you have accepted responsibility of you know, getting your arms around the problem and trying to address it. And there's you know, oftentimes little downside to doing something like that. And so those are kind of when and why you'd want to conduct an internal investigation. Okay, next, you're sitting there and say, okay, well, look, maybe I want to do this. If I do it, what are some of the important steps to think about? Because, you know, we've all done some kind of internal investigation, right? We've all looked into facts and gotten the documents and talked to people, maybe done some interviews and things like that. Well, okay, beyond that, Nick, what do I need to be thinking about? Well, here's what you need to think about. First, who to have conduct the investigation. A lot of times, in-house counsel is perfectly fine to conduct that internal investigation. In-house counsel do that all the time. And as in-house counsel departments are becoming more and more robust, more and more sophisticated, they become very, very good at this. One thing, though, you need to watch out for is protecting the privilege. Because one of the real benefits of doing an internal investigation is to be able to understand what happened, get your arms around what happened in a privileged context. Because what may end up happening is you do the whole internal investigation, you go to the board and you say, here's the problem. I think there is a violation. And they say, thank you very much. They're going to sit on it, okay? Well, you better make sure that's privileged, okay? And one of the things that makes my job easier as outside counsel is I don't have the dual role of in-house counsel, right? In-house counsel has a dual role of providing legal advice. They also provide business advice. Well, nobody's asking me business advice. I'm not smart enough for that, right? People, a good friend of mine, Tim Purdon from North Dakota, who I served with as U.S. attorney, says, you know, people are always telling me what's bad for business. I'll tell you what's bad for business. Windbreakers at your office. That's bad for business. And so that's what I know. The second thing to think about is knowledge about potential exposure. When doing the internal investigation, you want to know what you're looking for. What are the potentials out there? It's more complicated than just, let me find out what happened. Well, if you're thinking about a False Claims Act potential violation, you want to be thinking about what actually is a claim, right? What that misrepresentation may be, what are the damages going to be? Not just for purposes of advising the company on the proper exposure, but having the greatest potential benefit out of that internal investigation. So you can say, well, here's the potential exposure, and here's the dollars and cents value to it. Third is really credibility. You want to have somebody who goes in there and is able to say, look, I looked through this and I didn't find anything. I think we're good. And you want to be able to sell that to the board. Also, you want to have somebody that can talk with that prosecutor, right? Talk with that civil attorney. I've had this happen recently where a client, a good company, had a problem, and it's a new company, it's a smaller company outside of the state of Iowa, and he said, look, you know, Nick, we oscillate kind of between the red and the black. We're kind of a startup. We don't have the money to do all this. And so I called the DOJ attorney, and I said, look, here's the deal. And I said, what are you looking at? And he says, okay, let me do kind of a reverse profit for you. Identified the 3 issues they were looking at. I said, hey, you know, we've already, you know, produced some documents. Can you tell me the bait stamp numbers of the documents that you think really make your case on those 3 points? He goes, yeah, I'll do that for you, Nick. Saved the client all kinds of money, and now we know exactly what they're looking at, and we can address it. The last thing to think about in terms of representation considerations is, who do you represent? You got to be careful. I've had this situation before where, you know, one of the board members was implicated. So you got to think about that. Do you represent the company? Do you represent the board? Do you represent an audit committee or some special committee of the board? Do you represent individuals? Sometimes it's okay to provide some help to individuals, but for the most part, any individual who needs legal advice should be getting their own attorney, and oftentimes the companies will pay for that or arrange that. And there's ways to do that we'll talk about. Okay, so then you get started. We're going to get started on the internal investigation. What I'm going to tell you is, first, whatever you do, don't mess up the litigation hold, right? You're going to be held ethically responsible for the litigation hold, and all the in-house counsel in the room know exactly what I'm talking about. You want to make sure you got the right recipients, you've got the right scope, and you got the right directions to the employees, right? Hold the documents. Don't send them to me. Hold the documents, because we may need certain metadata and other things from you in a lot of cases, we just want you to hold the documents. And then you can't forget the IT department, right? Most businesses, almost all businesses, have some function where emails are deleted on somewhat a frequent basis to save space. You got to tell them to stop with these individuals, because you're going to be held responsible for that if you forget. What are some of the next considerations in terms of collecting and producing documents? Because keep in mind, sometimes you're in the situation of you got a government subpoena and you got to produce documents. Sometimes you're just collecting them for your own benefit. And one of the issues that I found that's most difficult to deal with is when you get a subpoena, and this happened to us out of the Consumer Protection Branch out of the Department of Justice. Along with the administrative subpoena, we got a 10-page single-spaced ESI protocol for electronically stored information. And it was as expensive as it sounds. They wanted certain metadata, certain ways, certain fields, not certain fields, and it required us to actually not just collect native documents from people across the West Coast, but to send a certain device. And we have an IT specialist on as part of our discovery team that goes out and collects it natively from the actual holders of the documents. So you're collecting it from the source, so you're not messing up the metadata trail there. Even if the government's not looking for that, right? And I've had sometimes too, they'll say, hey, look, you know what, Nick, I've had this happen within the last year. I produced over 2 million pages of documents to the government. How do you want them? PDF's fine. Really? Yeah. All right. Good luck. And you know, they got over 2 million pages of PDF documents. Good luck going through that. And because what you're going to want to do is take advantage of the metadata yourself. And there's a few different ways I do that. One is, you want to do advanced searches, right? Of that 2 million pages of documents, I would say 98% of it was emails. And when you're searching through emails, you want to be able to say, look, am I searching the email or the attachments or both? You want to be able to say, look, I just want to search the from function. I want to search the to function or the subject line. And you can do that with metadata, right? You can get in complicated, word searches of certain words, but not certain words. The other thing is search term reports. And I've actually used this with the government when they say, hey, look, I want these, but I want all these search terms included, right? And I said, okay, we'll send them back and we'll actually include one of our search term reports where we say, okay, look, you wanted all these search terms. Here's how many times those terms were in this document production or collection and how many unique hits. In other words, it hit on that term but no other terms. And they'll go through there. And this just happened to me recently. Said, okay, look, I understand that's, if you produce all those, it's going to be a million pages of documents. You can go ahead and get rid of that term, that term, that term, and I see your point on that term, get rid of that too. Well, you've done a couple of things. You've saved your client a bunch of money producing those documents, having to look through them. The other thing you've done is you've gotten a little bit more visibility on that government investigation. Okay, so now you've gotten the documents, you've collected them anyway, and the client says, okay, well, what do we do from here? Well, my preference is to say, hey, look, we're going to look through these documents. We're going to have somebody look through these documents for a few reasons. One, we want to make sure that we're not waiving a privilege. Two, we want to assess any kind of exposure you may have from there. And then three, kind of a responsiveness. Make sure they're actually responsive, because even if you run search terms, they may not necessarily be responsive. And they say, okay, look, that's going to cost a lot of money. We'll actually do budgets and tell them exactly how much money this is going to cost. What else you got? Well, we can do contract reviewers. You know, we contract with contract reviewers. They're a lot cheaper. Not as good as having an associate do it, but certainly good. And we can do the cheaper rate there. I don't know. You're telling me I don't have a lot of exposure on this thing. I just want to make sure I'm not waiving the privilege, but I really, it doesn't sound like I have any exposure. I don't want to have you look through hundreds of thousands of documents. Understandable. So in cases both in Iowa and in DC, I've entered into clawback agreements where we said, okay, look, here's what we're going to do. And sometimes we have the court actually enter it. Sometimes under seal. Sometimes we just agree amongst our in writing, and what you do is you say, okay, look, I'm going to run some privileged search terms, attorneys' names, law firms, different things like this, email addresses. Those documents that do not hit on one of those search terms, we're going to produce. Those documents that do, those are the ones we're going to review. It's going to be a much smaller subsection. You look at those, and then you produce the ones that are not privileged. And under clawback agreements, this is important. The courts say you do have to make some kind of effort to protect that privilege. You can't just say, hey, you know what, I'll send you everything. If you find something that's privileged, let me know. Courts are going to say, that may not be good enough. You got to make some kind of effort. So those are the different options we have in terms of collecting and producing documents. Let's see if this, oh, okay. Now, the next thing we want to do is we want to conduct the interview, right? Okay, we've all conducted interviews. And I think most of us have heard of an upjohn, right? Well, it's important, and I'll tell you why it's important and how it's kind of evolved. And so you sit down with the employee, and I was doing this recently, a couple of days ago. An associate walked into my office and says, Nick, okay, look, I need to go interview this employee of our client. And want to make sure we do it the right way. I said, make sure you do the upjohn warning, and let me send you some language and give you some advice. Here's the upjohn warning I give. I say, look, we represent the company, and I would actually identify the name of the company, and not you. We are here to gather information for the purpose of providing legal advice to the company, and therefore our conversation with you is protected by the attorney-client privilege. The privilege is between the company and our law firm, and not you and our law firm. The company controls the privilege, and the company may decide to waive the privilege and reveal the content of this conversation to the government or other parties without your permission or notice to you. Nonetheless, we request you keep this conversation confidential. Now, what do they do when they hear that? And initially, you think, boy, someone's going to say, wait a minute, I'm not talking to you. Almost never happens. It's kind of like a Miranda warning. And I've given a Miranda warning. People breeze right past it. Occasionally, our Attorney General's laughing. Our people want to talk. And occasionally, a problem you run into is they hear that and they go, wait a minute. Nick, do you think I need an attorney? Not so fast. You can't answer that question. You cannot give this person legal advice. They are not your client. So the typical way I answer that question is, well, look, I can't give you legal advice. Let's do this. Let me start telling you what I'm talking about, and we'll go from there. And then you can get into the interview. And if some point during that time they say, look, based on what you're asking me, I think I'd like to have an attorney, then you can stop and they can get an attorney. You can arrange that. But that's an important thing to keep in mind when you're giving the upjohn warning. And a lot of times, you know, people will fail to let them know that, hey, you could reveal this, right? Because you could be cooperating with the government and reveal it to the government, or you could reveal it to other parties via joint defense agreement. Okay, so that's the upjohn warning. Then, okay, hey, look, you know, again, as we're sitting here in the conference room, let me tell you a couple of other things. If you're going to go off and do this, is you got to make sure, you got to be very, very careful about memorializing these interviews. And all this is kind of in heightened important after the AIDS memo. And we actually do trainings on this. So we have a white-collar group in our law firm, and we have former AUSAs from Chicago and Indianapolis and former SEC attorney. And we have a white-collar group. We do trainings across the firm. We do it via video conference on white-collar issues. There'll be like one every couple of months. And one of the things is on interviews and memorializing interviews, because we want to make sure people are doing it the right way. And that is, ideally, you want to have a second attorney present, taking notes and preparing that memo. The memo is going to be protected by the attorney-client privilege and the attorney work product doctrine. Because here's the background on Upjohn. Everyone always hears Upjohn and thinks about, well, it's a warning. It's a case about a warning. It's not really a case about a warning. What Upjohn was is a situation where a company was looking into a potential problem, and the general counsel sent out questionnaires to employees about that problem. We need to know everything about this. And somebody sought it and discovered it. The United States Supreme Court said, not so fast. Can't have it. And they said the control group test for the attorney-client privilege wasn't sufficient. Rather, if you were talking to employees who are outside the control group even, for the purpose of providing legal advice, give the information to provide legal advice to the client, privileged. And that's really what Upjohn is about. So, you know, this memo is going to be protected by both the attorney-client privilege and the attorney work product doctrine. Now, a lot of times what you see on the memo is just, you know, attorney-client privilege, work product doctrine, right? We can do that in our sleep, and it's sort of part of our DNA to put that on things. Well, sometimes courts say, well, that's not determinative. I really need to look at the substance of this to decide whether this is actually protected. And so what I tell attorneys to do is to document the basis for the work product. In the opening paragraph, you know, I want you to make clear that this is not a verbatim transcript of the interview. It'd be difficult to actually do such a thing even if you wanted to. But if it is a verbatim transcript of the interview, guess what a court's going to tell you? Down the road, you may have a problem. The other thing I tell them is to not only say, you know, to explain that this contains my thoughts, mental impressions, and conclusions as an attorney. Now, some attorneys will actually say, hey, look, in order to have it protected by the work product doctrine, you need to actually have overt opinions in there, right? In other words, when you're interviewing somebody to say, okay, look, I've interviewed John Smith, and he said X, Y, and Z, you know, that seems inconsistent with something, that seems questionable to me. Those kinds of opinions laced in there, I don't think you need that, and I think it's actually a problem, and here's why. Down the road, you may be sharing that interview memorandum with his attorney. And if you enter into a joint defense agreement, that John Smith's attorney gets that, and guess what he's obligated to do? He's going to look at it and go, as my client, I'm obligated to tell you your employer thinks you're lying. Right? That doesn't help the relationship. And so, you know, I look at this case law all the time, and courts do not require that. Rather, it is sufficient that when you are taking notes, you are using your skills as a lawyer and your knowledge about that case to decide what to write down, right? What's important, how to write it down, right? And that's usually sufficient. And so, also in the Upjohn warning, usually people just say in memo, Upjohn warning given. Well, under Gates and the focus on individuals, what I do now is to make sure that they document exactly how the Upjohn warning was given and that the individual said they understood it. Additional considerations. Okay, so in addition to all of that, I want to give you a couple of other things to think about. Joint defense agreement. So now, maybe you're in a situation where the government says they want to interview some of your employees, right? Okay, well, typically what happens then is you enter into a joint defense, or sometimes called common interest agreement. And so that you can share privileged information amongst you without waiving the privilege, right? You want to go kind of more back and forth, not just collecting information. And a lot of times what has often been the practice, and was the practice when I became an attorney, and happened a lot in Boston where I practiced for a while, is to say, okay, we're going to do an oral joint defense agreement. And we both know what that is because we both practice in this area, and that'll be sufficient, and I'll explain to the client, but that's going to be sufficient. And, you know, we don't want to have a document out there that maybe someday the government gets their hands on. Look, the government knows you're entering into these agreements. They don't ask about them. They don't really care, okay? But your client may care because your client may not fully understand the agreement you're entering into, that he or she is entering into. In particular, a conflict waiver. Now I used to do them oral, now I do them written. And when I do a written joint defense agreement, you have a conflict waiver in there. Because what if it turns out you actually end up adverse to your co-party that you're entering into this joint defense agreement for, right? What if you end up having to, let's say, cross-examine them at trial? Well, if they've shared attorney-client privilege information with you, that would be a conflict. And you don't have to tell your client, look, now you have to find another attorney. Your client's not going to be happy with that answer, right? So we put in there, hey, look, there's a conflict waiver here. We understand that, hey, look, if one of us backs out of this, that the conflict's waived, and we can still be adverse to one another. And then, you want to document how the privilege is going to be controlled with respect to documents and things like this. Third parties and experts. Sometimes it's necessary to have accountants in particular and things like this to help you out. Well, it's going to be important. They can be part of the privilege. They can be. But it's going to be necessary that they're necessary to provide legal advice and that they're under supervision and control of attorneys. A lot of times what I hear now from in-house counsel is they want to say, hey, look, I want to have security personnel conduct interviews. Could be possible. We can work that out. But let's work through it together. They need to be under the supervision and control of either you as in-house counsel or me as outside counsel. And we got to be careful and document that. Okay. The last thing is reporting results. So a lot of times the knee-jerk reaction is to say, okay, write me up a memo, shoot it over to me. Maybe, yes.
I didn't quite get what this conflict waiver is. Can you just give me a sentence that says it?
Absolutely. So the conflict waiver is this, and here's how it would come up, and here's how we deal with it. So you and I are entering into a joint defense agreement together, right? We've agreed that we have common interest in this litigation. And therefore, with respect to the government, we want to be able to share information, right? I'm gonna tell you a little bit about what I know, and you can tell me what we know. We're maybe share litigation strategy, right? We're kind of on the same side here, and we're going to start doing that. We're going to start sharing information, and that's important to be able to do because otherwise, if you don't have an agreement, once my attorney reveals this to you, or once I reveal this to you, privilege is gone, right? Now the government can come in and get that information. You want to prevent that. So we want to be able to share privileged information, and we go do that. Well, then down the road, you decide, wait a minute, you know what? I decide that I'd like to cooperate. I don't want to go to trial on this. I think I'm going to lose. This does not look good for me. I'd like to now cooperate with the government. Uh-oh. Right? So we got to make sure we've documented that you cannot reveal to the government privileged information I've given to you, right? Because the government's going to tell you, tell me everything you know, right? So I'm going to make sure that you're not revealing the privileged information I imparted on you to the government. And then in addition to that, I know now you're a cooperator. And what's going to happen when I go to trial is you're going to testify against me. Well, because you have imparted attorney-client privilege information to me, I would typically have a conflict in terms of being adverse to you now, in terms of cross-examining you, because I now have information I otherwise wouldn't have, right, about you. And to be able to use that to my advantage in cross-examining you. Well, as part of the joint defense agreement, we want to say, look, we're going to waive that conflict. I'm still going to be able to cross-examine you, and that's important because otherwise my client has to go get a new attorney, right? And they shouldn't have to do that just because you backed out of the agreement. And so we have a paragraph in the joint defense agreement that handles that, and that's another reason why we do it in writing, because that's a heck of a thing to be able to explain to somebody as you're explaining everything else and somebody's going through a very difficult point in their life to kind of explain that, right? And so we do it in writing. And when I do them in writing now, A lot of times it used to be you have the attorney sign it, right? Okay, yeah, I've talked to my client about this, I'll sign it. Now I'll have the client sign it too, you know, and to make sure that everyone is on the same page with any rights they're waiving, with how things are going to happen, because if things go south, as they sometimes do, you don't want to end up in a situation where you got to bow out of the case, or somebody saying, no, wait a minute, I thought you were my attorney, so you really can't share this information with the, you know, with the government. What's going on here? You want to make sure everybody knows their rights and everyone's on the same page. Anyone else have any questions on the joint defense agreements? Okay. You know, so then reporting the results. There's actually two people you may end up reporting the results to: the government and your client. First, you're going to report them to your client. And in reporting results to your client, a lot of times the knee-jerk reaction is to say, okay, write up a report and give it to me. Makes sense. And sometimes you have to, right? Where they're, you know, 100 pages long, and it's tough to have all that information and not have reports. However, the practice typically is to do it orally, especially if you're conveying to your client that they have violated the law. Once you put that in writing, you kind of lose control over where that gets sent. And even though you're handing it to your client and it's privileged, if you have a board member that forwards it to somebody, hey, look, you know, I sent it to my accountant because I wanted him to give me their opinion on this, or something like this. Oh, no, you know, it takes one person to waive that privilege, and now the government can get it, and that's the keys to the kingdom, right? So oftentimes, actually, is what you do is you report orally. If you need to, you can do a handful of PowerPoint presentation slides, and the same goes for the government. Typically, when you go into the government, I've done this several times, is you go in there and say, okay, look, here's what happened. And you don't do a written report, because keeping in mind what's going to happen is that government's going to have that written report. Anything you convey to the government is going to waive the privilege. There's some 8th Circuit law that is a little bit to the contrary, but you can generally be sure that anything you convey to the government is going to waive the privilege. And so you got to be careful of that, because usually if the government's investigating you, there's probably civil litigation lurking somewhere out there. And so you got to be careful of that. Okay. Any questions? Yes, sir.
Do you have different advice depending upon the size of the employer, or whether the employer is a public or is a private entity?
So, you know, size of the employer, the question was, you know, do I have any different advice depending on the size of the employer, or if the employer is a public entity? Yeah, so, both of them complicated a little bit. So, size of the employer sometimes will make it easier because they'll have more resources, and sometimes they have a little bit more sophisticated means to collect documents on their own, to and things like that, and processes in place to get information. But for the most part, no. Actually, sometimes where I confront the most problems is on a smaller employer, where everybody knows each other's business, and you convey to everyone you interview, look, we request you keep this confidential. Not just for our sake, but for your sake and your friend's sake. Because as soon as you start conveying this information that you know, hey, look, I just went in and talked to Nick, and here's what he asked me, and here's what I told him. Well, a year from now, when that person, that employee you talked to gets deposed, you have just lengthened their deposition, which they're not going to appreciate. And they're going to be sitting there thinking, look, I don't remember if I knew this in real time or because my buddy told me, right? So you've complicated both your lives there a little bit. And so sometimes that's difficult, right? If you're sitting in an office of 3, 4, 5 people and getting interviewed by one, it's a difficult situation to look around and say, okay, is anyone going to talk? What did you guys say? What did he ask you? Whereas with a bigger company, there's a little bit more anonymity about that. You can kind of do the interviews discreetly, not in front of colleagues, and a lot of times their colleagues don't even know they've been interviewed. Next, with respect to a public company, of course, there's more requirements, right? You may have a reporting requirement. And so that is going to be very, very important to keep in mind as you're doing this. And that's a big complicating factor. Any other questions? Okay, going. We're still in our free consultation period here. Okay, all right. If this interested you at all, we're actually going to be doing an ABA standalone event on October 12th at the Marriott Hotel here off the Skywalk. And we're going to have the head of the Department of Justice's Securities and Financial Fraud Unit, as well as the U.S. Attorney for the Southern District of Iowa come in. And then they're going to talk for about 15-30 minutes on the Department of Justice's new priorities and new focuses. And then they're going to drop back into a panel of me and a couple other defense lawyers, an expert from PwC and in-house counsel to kind of roundtable issues. And we're going to kind of we're going to talk about internal investigations, but we're also going to be talking about what do you do when the government shows up at your door, right? The windbreakers at your office scenario, right? How do you handle that? What do you do then to take matters in your own hands? It's in the internal investigations. And then, you know, lastly, the cooperation piece. Exactly what does that look like? And I think it'll be fun because you'll have the government people actually in the room commenting on it. If anyone's interested in that, it's free. We're actually here for a free reception afterwards. It's only 2 hours, and then there's going to be a free cocktail hour afterwards. Just shoot me an email, and I'll send you an invite for it where you can register. All right. Thank you very much. I really appreciate it.